Cloud. Okay, well, it's recording. And I'm trying to get us to stream on Facebook. There we go. Okay. Share to your page. Share to Family Law. Go live. Okay, and I have this pulled up, Joe. All right, we are live, and here we go. Welcome, everyone. Thank you. It's 12:01. We did okay, considering if you'd been with us just a few minutes ago, you would have seen a different deal, right, Joe? So technology, Murphy decides to show up. I'm going to have Joe take himself off of mute. And as we welcome you to today's webinar, I'm Angela Moonin on behalf of Stanley Law Offices. Thank you so much for joining us. We have with us today attorney and partner at Stanley Law, Joe Stanley. Good afternoon, Joe.
Good afternoon, Angela.
And we are talking labor law. That's a fancy way for saying construction today. So if you are a construction worker, if you have a loved one, a family member, a good friend that you know is a construction worker, or if you're just simply interested in the fact that we know in this part of the world at this time of year, there's lots of construction going on. And so there are going to be some good insights shared today. We are taking your questions. I have my cell phone. So please, if you have any questions for Joe, don't hesitate to type them in the Facebook comments, and we'll get back to you with an answer. I'll make sure to ask Joe what your question is. So with that, Joe, I'm going to turn it over to you and give some context for why you chose to want to talk about construction today and at this time. And then we've got some slides to share with everybody. Take it away, Joe.
Thank you, Angela. Well, I mean, construction is more prevalent this time of year, but construction activities take place year-round. And in New York, construction workers are fortunate that they have the best protections under the law of any state in the union. New York protects its construction workers better than any other state, which is very good if you are involved in the construction field. We have regulations that understand the dangers that are inherent with the construction trades, and in fact are inherent with not necessarily actual construction activity, but involves activities that work under hazardous scenarios, mostly elevation related risk. So New York over the years has understood the dangers involved and has provided the construction worker with the opportunity, and I say the opportunity, to obtain additional compensation and have additional legal rights, but they are not readily understood, and they are very, very fact specific. And that is the purpose of this webinar. This is a practice that we spend a lot of time in. It is one of the most fascinating fields of law as a tort lawyer or a personal injury lawyer, because the stacks of law cases concerning construction litigation are this high, and compared to everything else, they're this high. So the law is sometimes confusing at best. and sometimes it doesn't make any sense logically. And so I've been handling this for as long as I've been a lawyer, and I have seen the unbelievable changes that have taken place in these protections. And they're the same words, but the courts have changed the interpretation dramatically over the course of the almost 40 years I've been doing this. My partner has been doing it for 25, and he has seen 25 years of dramatic changes, both in the favor of the injured party and not. And it's just incredible that the same words can have an absolutely 100% different interpretation based upon time, location, and judge. And so as I leave it with that.
That's amazing. I mean, and when you imagine, Joe, someone trying to go it alone. I mean, if you're hurt on a construction site and you try to go it alone, very low odds, right? That because of that complexity and how much has to go into this.
Well, I'm not sure that you could go it alone, because you would really not even have an appreciation of how the subtleties of how this works. I mean, this is not like you fell in a grocery store or you were even in a car crash. You might have some entity that you would deal with who was legally responsible. That's not how this works. The nature of the process is not something that it just doesn't work like that. You're gonna be involved with the process from workers' compensation aspect, and you might only understand that that's all you get.
Okay, all right. So we're going to touch upon this today, Joe, right? But the importance of, because there are two, and often these cases, as in so many personal injury cases, there can be a workers' comp case right alongside the personal injury case, in this case, a labor law case.
Yeah, and 90% of the construction accidents involve a workers' compensation claim. The other 10% is an independent contractor or a sole worker or whatever that scenario is. Yes.
Gotcha. All right. Okay. So we don't have any questions so far, Joe. So for right now, we're going to go into sharing the screen, and let me just give us a moment here and we'll get this rolling for everyone. Okay. Can you see that all right, Joe?
I can.
Okay, so again, if any questions today at all, we're talking construction in terms of legal speak, it's called labor law. Stanley Law has a dedicated history and wisdom in this arena, and it's a specialized arena of personal injury law. You don't want to go it alone. You probably couldn't go it alone, as Joe says. You need and you don't want a general practitioner because the laws are complex, and we're going to go through them. And you start to see some of these slides, Joe. I was reading these last night and I thought, oh my gosh, yeah, this is this is labor law. Okay, so take it away, Joe.
All right. Well, the first section, sometimes this is called the scaffolding law, but that's not really accurate. This is section 240, subdivision 1 of the New York labor law. And what it says is all contractors and owners and their agents, except owners of 1 and 2 family dwellings, who contract for but do not direct or control the work in the erection, demolition, repairing, altering, painting, cleaning, or pointing of a building or structure, shall furnish or erect, and will go on. Really what it says is that they have to provide proper safety devices under the circumstances. Now that statute, on its face, its interpretation has changed so much over the years, is that hard to imagine. The second half of that, by the way, applies to architects and engineers, and that they have a special exemption that for most of the time does not come into play. But the relevant parts of the law are: what is a contractor, owner, and agent? Interesting questions over the years: who they are, what they are, and who's responsible. Hundreds of cases just on those issues. The next sentence: except owners of 1 and 2 family houses. What that means, says dwelling. I use the word houses, but what that means is that 1 and 2 family owner occupied houses are exempt from the provisions of this law. Okay. And that's an important exception, because that means most homeowners are not covered by the legal liabilities involved in this statute. Then the next part of the statute is the work that is covered by the absolute liability of this statute. And I haven't addressed that issue yet, but this is what is called an absolute liability statute. In effect, it may not absolutely be an absolute liability statute, but legally that is how it is referred to, which is different than the standard negligence where you have to show fault. The standards in this are that if you violate the safety standards and you are involved in the kind of work that is covered by the statute, and you are one of the contractors, owners, or their agents, you are then responsible. How's that for a lot of words?
That's a lot of words.
But what it means is that if you are on a construction site, or if you're just doing the kind of work that we're going to talk about now, and the proper safety devices that are defined by the law or the courts are not provided, then the owners and contractors are responsible for all of your injuries, regardless of your fault. And that is where the absolute liability comes in. There is no comparative fault involved in this particular statute. That doesn't mean, no, we need to go back, Angela, because that doesn't mean that your actions are not considered, but they're looked at in a different way. All right. Now, the kind of work that is covered by 240, and we're going to talk about the next statute, 241-6, is different than this statute. All right. This statute says all areas in which construction, excavation, and demolition work is being performed shall be constructed, shored, equipped, guarded, arranged, operated, and conducted as to provide reasonable and adequate protection and safety to the persons lawfully employed thereon. And then it also talks about the 1 and 2 family dwelling exceptions. This is solely applied to construction, excavation, and demolition work. 240 applies to the type of work that we talked about, not this kind of work. In other words, it talks about alteration, repair, pointing, and those kinds of things. This statute is only involved in a construction, excavation, and demolition work. And this statute is a vicarious liability statute, but it is not an absolute liability statute. How's that?
Okay.
All right.
Okay.
The difference different than 240 is that if you are a contractor and you are working, have workers on the job, and you violate this provision, then you are responsible, but the comparative negligence of the employee or the person hurt on the job site is a factor in this liability and your amount of your damages. Now, we haven't talked about how you have to prove legal liability in this case. You see the part where it says the commissioner may make rules to carry into effect the provisions,
of the subdivision. Right.
Fascinating. Back in the day when I was a young lawyer and throughout the 1980s, this was a self-effectuating statute. You know what that means? That means that the statute was interpreted to mean that all contractors, owners, etc., had to provide a reasonably safe place to work, as this statute says. Okay. But lo and behold, without any statutory change, the courts decided that it was no longer a self-effectuating statute, and that the only way legal liability could be determined under this statute is that there was a violation of the rules that the commissioner shall promulgate under this statute. Now, that sounds simple, except that the rules that were promulgated under this statute have not been changed since 1970s. The rules were abrogated by and taken over by OSHA in general because they were workplace safety rules. So what in effect happens is that the rules determining legal liability under this statute have not changed since the 1970s, and sometimes have no relationship to the actual construction world of today. And even though OSHA replaced these rules, the courts have never seen fit to apply the legal liability under OSHA rules to this statute.
So meanwhile, there's so many other things that have changed, but this has been in place for decades. Is what
50 years
yeah,
with no change.
with no change. Now, how about this, Joe? What is this trying to frame here?
This is the section 200 applies to essentially all workplaces. It's the general requirement that all places shall be so constructed, equipped, arranged, and operated as to provide reasonable and adequate protection to the life, health, and safety of all persons employed therein. This is called the general section 200 of the labor law, and this quote unquote codifies or puts in statutory form the common law negligence standard. In other words, all employers that are covered by this are subject to the rules that are promulgated under these statutes that were put in place in the 1970s and are much more general than just construction sites. Okay. And there's a defense of comparative negligence to this statute, and its applicability to construction accidents really is limited to those who are active participants in the event. That's my words, not what the courts say. They essentially, you have to direct and control the work or be contractually responsible for the work to even have this provision apply. And it is not much different than a common law negligence claim, meaning just the regular old law that is not statutory applying to unreasonable conduct.
Okay.
So those are the three general ones. And I think what is covered, now we can go back. We'll go back. And we've talked a little bit about the difference. Let's go back to 240. What is covered? What is covered here, and what's important if you are involved in an accident to be covered by 240, you have to be involved in their erection, demolition, repairing, altering, painting, cleaning, or pointing of a building or structure. Now, what do those things mean in a construction in under this statute? Well, for each one of those categories, there are hundreds and hundreds of court determinations that have changed over the years, determining what erection is. Now, does that mean does it have to be a substantial erection of a building? Does it have to be minimal? Does it have to be a mandatory or just can it be a voluntary part that's supposed to be there? I can remember a case involving this particular section in which the court on its own made up something that was brand new to the law to find that it wasn't covered because they didn't like it, because that was the status of the judiciary at the time. What is demolition? But you would think that that's a pretty easy one, and most of the
Right,
time,
right.
we got that one right. I mean, with demolition, I don't recall ever having an issue with the demolition. Repairing it is probably the most interesting one because, again, the definition has changed over the years, and what you and I consider repairing may not be repairing at all. And that is a incredibly fact specific category that needs to be evaluated and handled from the inception, because sometimes framing of the case is more important than what the actual event is. What is a repair versus maintenance? And that's that's the common. Is a repair maintenance? Well, your understanding of what it is and even my common sense understanding may not be what a repair is.
So when I'm just going to stop share, Joe, so people can see your face. When, so it's got to be difficult at times, is it not, when you're talking with clients and trying to, I mean, how in depth do you get with a client who's come in, who's been hurt, or her husband's been hurt on a construction site, or his wife, or whatever the case may be? How detailed do you get? Because it's got to be incredibly frustrating for clients, because I think repairing, like they're repairing the building, or they're repairing the sidewalks, or they're repairing
it doesn't even have to be, it can be repairing something that has nothing to do with construction, because Section 240 does not have to have a construction related activity. So this could be repair. There have been cases that involve billboards. Is this a repairing of a billboard? Is it a repairing of a window?
Okay.
Is it a repair? It can be repairing of anything. And the next provision is altering. And that doesn't have to be in a construction setting.
Like, it's not what we see in our mind's eye when we think it's basically if that person's taking any kind of action to do those things, repair,
right,
paint, et cetera, et cetera.
Yeah.
Okay.
So, but it does not have to be in a construction setting. And many times we interview clients that are workers' compensation clients, and we develop the case and the facts because, and as I said before, it's not a common sense understanding that you are going to be subject to these additional protections.
Right.
So
right.
When we interview clients, we've been doing this long enough to know what to look for. And so what I say is that you should get to a lawyer as soon as possible so we can investigate the facts, develop evidence of the facts, so that we can then show that it is covered under the statute, because the defendants have become very knowledgeable as to what isn't covered and what their defenses are, and that sometimes proof becomes incredibly difficult if you don't get to it in a very timely fashion.
Now, we have a question, Joe. Is it harder to prove a case, or are there different aspects of the case? Some of this, if this individual was hurt at a municipality, so the city, something that the city owns.
Well, that's a layer that's added on of complexity, because they can be owners, they can be general contractors, municipalities can be. The issue with a municipality is that you have to file a notice of claim within 90 days. And if you do not, that adds a whole layer of defense that if the 90 days expires, the attempted relief for a late notice of claim raises a whole series of defenses that sometimes you don't want to be in, because
like the guy isn't really hurt, he just
no, actually they just the defense, the easiest defense is we didn't know about it, even though we might have been responsible as an owner, but we just hired these people and we know nothing about it, have no information. And that it can be a defense to a late notice of claim legal motion. So
So they can just opt themselves right out of any kind of liability because they were unaware and it wasn't claimed within the 90 days of
right, it is
the
very
accident
important.
happening.
But that's another reason that if you have any kind of substantial injury, particularly in the construction sense, but you may not even know. We've had multiple construction cases where actually the worker didn't really even know who hired who to do what. Um, and it turns out if it's a school district or a municipality and it's more than 90 days, the your claim could be lost, and it has happened.
All right, so let's go back to sharing the screen, Joe, and pick up. So you were walking your way through. Language is incredibly important, and it doesn't, common sense definitions that we might use in layman's terms on a day-to-day basis really have nothing to do, nothing or little to
Right.
do
When
with
we can
the,
go back to 240, we can go back to the first one because
okay,
I think we
okay.
left off at altering. There's another, altering doesn't really mean what you think it means. And again, painting is pretty clear. The question is, does painting have to be in a construction setting or not? Probably not. Cleaning, the law has been up and down and all around on that issue. Uh, I have a history with cleaning over the years on court's interpretation of that, and I'll leave it at that. Um, some of the arbitrary determinations that arise, these are so fact specific, and it can even depend on what part of the state you're in, because the appellate courts in certain different regions look at these statutes differently. Doesn't seem fair, but that's the way it is.
Wow.
Uh,
And then you
so
also practice in Pennsylvania, Joe. So the Pennsylvania laws versus New York state laws, very
they
different
don't
deal.
have any of these. You don't have to worry. Essentially, what they have is common law negligence there. They have,
Okay, like
so
the
they don't,
200, this
right,
last one that we
essentially,
looked at. Yeah, yeah,
essentially.
yeah.
It
This
doesn't,
one
it's
is
not that
closer to
it's
this.
not that section, but that's what they have.
It's of that ilk. Right, 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 right. Okay.
So, then the next issue is, do the facts arise to a level of that there was failure to provide an adequate safety device? And this lists some safety devices. It's not all the safety devices that are covered. There's a dispute about whether the safety device was the actual cause of what the injury was, or so-called legal, what the word is, proximate cause. There's a whole series of other issues that arise out of this. One of the critical things that does look at the employee's activity, that sounds a lot like comparative negligence, which the courts have tried to actually do. They call a comparative negligence by a different name. It's called sole proximate cause, meaning that the injured party's activity was so significant that it was the only cause of the accident, and then the statute doesn't apply. Again, to me, that is just a way of trying to bring comparative negligence into a statute that is not a comparative negligence statute. But the law, again, keeps changing. There's new interpretations every year about these issues, and it gets incredibly complicated. And I don't
I
anybody
mean, I can
sitting.
see we've been through 3 slides, and even within one slide, the first slide here, there's, as you said, hundreds. I mean, hundreds of different variations on a theme here on every action that you're, so I can
Well,
see how you can, I mean, you've got to know this stuff. And do you and Rob and the team, do you have to, like, how are you notified when something, this is like from an outsider's perspective, right? How are you notified? How do you know when these things are changing, these nuances?
well, we digitally get new cases every month from the appellate divisions and from the Court of Appeals. So we keep track of them. We
Okay.
we have kind of a
Wow.
score. We have kind of a scorecard because we comment on what's the latest ridiculous case that deals with
Right.
the
Well,
construction. I
well,
mean,
now let me
and
ask you, is it grandfathered? So let's say you already are underway with a particular
no,
case.
no,
It's not grandfathered. So all of a
no,
sudden, a whole new set of rules could apply to a case you've been
absolutely,
working on. Oh my
yes.
goodness.
Well,
Oh
and
my-
and more critically, we have declined cases from a couple of years ago where there was no case that the law changed and became a case.
It became a case. Oh my goodness. Oh my goodness. All right. So construction versus non-construction activities, Joe, talk a little bit about that.
Which we already have. Section 241(6) and the rules under that statute only apply to construction, demolition, etc., construction type activities. Section 240, as we said, applies to non-construction activities, and that is a big issue about people not understanding that. There's a lot of rights that could be lost because of repairing, painting, altering, etc., that are not occurring in a construction setting. So, but 241(6) and 200 require a 200 applies just generally to everything. But
General, right.
241(6), it requires a construction setting.
Okay, I gotcha. All right, so you've touched on this to some degree, Joe. Is there anything else on here though that you want to
Well,
highlight?
we can talk about section 241(6), and we talked about the regulations, but we didn't talk about how these regulations are interpreted. I don't have my book in front of me. I know somebody stole it as usual. Oh no, here it is. Here it is. See this book? This is all the regulations that are under this New York Industrial Code. This book here, somebody generously gave it to me, a vendor. Okay, there are pages and pages of regulations, many of them nonsensical and don't apply to much of anything. But the courts have made a determination that the only rules in this book that apply to the legal liability under 241(6), believe it or not, this was again when they changed the law, have to be a specific rule versus a general rule. You like that one?
Oh my gosh.
All right, and again, the criteria for deciding what's a specific rule versus what's a general rule eludes me. I mean, the logic of them eludes me. I mean, I know what they're doing.
Right.
And again, if it's not specific, it doesn't apply to your accident. If it is specific, it can be used to show legal liability. And again, there are cases, I don't think there's still every regulation there's been a ruling on whether they're specific or not specific. Some of the appellate courts may differ about whether a regulation is specific or not, or parts of it are specific, or is it specific as to the facts of your accident and not specific to others. It is, we'll put it this way, if I had to choose, this wouldn't be the way to do it, but
Right.
keeps lawyers busy.
Yes. So who's responsible?
Well, we touched on this, and they're under 240 and 241(6), owners. That seems to be a pretty easy one, although sometimes owners are not owners under the law.
Well, and as you said too, somebody hired somebody, and they're bringing in different workers and who works for who and who's responsible.
Yeah, and that generally doesn't get an owner out. But there are some scenarios where we won't get into those. But
what is this
general
home exception?
Pardon me?
Two-family home exception. I'm not even sure what that means.
Well, no, that's what we talked about, but we'll get to that. Okay. Owners, general contractors and agents, etc. Are they contractors? Are they construction managers? Are they directing and controlling the work? These become legal defenses. They become factual defenses. And when you have a large construction site, there's a whole lot of things going on. People that are actually involved in the work, and those who are not, and those who are not are always saying that they are not a person under the statute who is responsible for anything that goes on. This two-family home exception is the one or two family homes that are owner occupied are not covered by 240 or 241.6. So if you're an owner of a 1 or 2 family home and you hire somebody and they fall off a ladder because it wasn't tied off properly or it wasn't the proper ladder, you are exempt from this statute. Unless you gave them the ladder and you told them how to do it, which I
Right.
wouldn't, which generally doesn't happen.
And so this is fact specific. This is what you were alluding to earlier as well, Joe.
Right.
That repairing versus, and then even within the repairing, what were they repairing? How are
Right.
they?
Well, the statute 240 only applies to elevation related risk. Now, this definition, the risk, obviously the safety devices are necessary that they talk about because you're working in an elevation. So how do we define elevation related risk such that safety devices are needed? Good question. That definition has changed over the years also. The current definition is really works like this, is that if it's demonstrable force of gravity issue, then it's probably an elevation related risk that is covered by the statute. But
Okay.
what does that really mean? For instance, there are cases now that if you have a whole line, say, of pallets or parts that are used in construction lined up against the wall and they weigh 150 pounds each, but they're on the ground and one of them falls over and hits you on the head and hurts you really badly. Is that covered? Is it supposed to have been secured so it didn't fall and hit you? No, one would think that that's covered. At one point it always was, then another point it never was, and then it was again, and now it seems to be, at least in some of the appellate courts, to be an issue again. And is it, some of them we're talking about, well, does it weigh enough? Is a risk based on weight and force? That's why I say these things are moving target. Suffice it to say, the elevation related risk part is something that is a requirement to coverage under the statute, and it is an issue that arises at its ugly head many times. And we've talked about repairing, cleaning, pointing, altering, about, those are the activities that have to be happening at an elevation related risk.
So how does all of this work, Joe, with a compensation claim?
Well, most of the time when people are calling us, it's because they got hurt on a construction site and they have difficulty with their workers' compensation claim.
Mm-hmm.
And then we evaluate every case that comes in the office and we say, well, that you have a claim against the owners, contractors, et cetera, because this is covered by the special statutes, either 241 or 241.6. And if you would like us to proceed, we need to get going on it right away because these are very fact specific. And workers' comp is parallel in a sense, is that these cases go on. Workers' compensation, and we've talked in the past, has lien. They have a lien on all the money they pay out of any of these lawsuits that are brought under these statutes. But it becomes way more complicated than that because all of these parties, say there's six potential defendants in a case on a big construction site, and they have all sorts of complicated interrelated insurance coverages that may or may not even include the workers' comp coverage. Not that affects the injured worker, but it can affect how the process plays out in litigation, which, by the way, didn't talk about, forgot to put on the slide. Almost all of these cases are litigated. They
don't get settled.
Extremely rarely. just because of all these issues we talked about. And because of the nature of the injuries are usually very significant. So insurance companies just in general they don't pay big numbers without litigation. It's just the nature of how it goes. Okay.
Okay.
And I can say a significant number of these don't get resolved until after an appeal to an appellate court for the same reasons we talked about, because there's a decision that says just about anything, and there's a defense that you can raise about anything. So,
So it has to, okay, so that's the last slide, Joe. So, in other words, you're going to court. I mean, you're going to go, if you've got a construction related accident, you're going to court. Almost invariably.
If you didn't, it's a very unusual circumstance.
Unusual. So on average, I mean, I know average is a terrible word as it relates to personal injury, because it's every case. And I know you said this over and over and over again over the years, Joe. Every case is so different. And then you see all of the variables here. You really say, wow. I mean, for every labor law case you've ever fought and won, or just had in your firm, you and Rob, I mean, there had to have been unique nuances to every single one of them.
There is, and we have been fortunate to be very successful in our cases. And I think it is because we are very familiar with how this works. We are ready, willing, and able to litigate every issue, and we try to get out in front of them. And that's why it's important to investigate, get the facts, get the witnesses, frame the issues properly at the beginning, and it makes things way smoother as you go along in the process.
Well, that's what you said. You said the preparation is so vitally important in this, because you otherwise, I could see with all these trip ups that you could really back yourself into a corner. Your case could be done over.
Yes. Oh, I mean, one fact can make the difference between a $1 million case and zero.
Oh my goodness. Oh my goodness. So talk a little bit about like what is it? Because you really, not to say enjoy the cases, because that's even using that word, but there's a reason you do the work that you do. And obviously the only reason you do the work that you do and Rob does the work that he does, someone's gotten hurt. And typically in construction, probably pretty badly. So, so there's not a joy in it, but certainly there's a level of satisfaction, I would think, in working the case, doing the prep, and seeing it through to the end, and seeing these folks who are 9 times out of 10 just incredibly hard workers in their lives, right? Salt of the earth. I've heard you talk about some of these clients. Share that perspective, the human perspective of this, Joe, of some of the things you've experienced over the years, and why it is that you do what you do when it comes to, because these are complex. These are not walk in the park cases. Okay. So not that any of them are really, right? But certainly this is much more a time of investment and energy, and a much bigger gamble, because so many ways for it to go sideways on you.
Well, I've always found over the years, the more challenging, the better, but some people may not agree with that. But I also, in my prior history, I was a painter, I was a roofer. I have gotten to know a lot of construction workers over the year. One of my investigator is a former client who was a construction worker who got injured, and we got an excellent result. And you know, it's very rewarding when you get to know these people. A lot of these guys, they don't have any idea, you know, they can't work anymore, and they think they're stuck with workers' comp. And I say guys because it's mostly men, but we've actually had our share of women, particularly becoming more commonplace. They get just as hurt as men. And their issues are a little bit different usually, but it's interesting to see how, when you explain it to them, do they you know, really, you know, because logically some of these things don't make sense. And particularly the ones who've been involved in the comp system for any period of time, if they see any remedy that's outside of comp, they're ready, willing, and able to get it, because workers' comp is not, it's not the remedy of first choice. If you had a choice, if you have a bad injury on a construction site and your only, choice is workers' comp, you at some point are going to find out that your compensation is very limited. And so,
So
it gets,
you work in tandem, Joe, in these even in these labor law cases, you work with the Fallons, you work with Sheila or Megan or Arthur, your dedicated workers' comp team, and they work alongside of you in these
well, you
labor law
have to,
cases.
I mean, first of all, it's critical to get the client as much protection as he can when he's hurt. But second of all, some of the facts developed at workers' compensation court can impact significantly the outcome of any construction litigation. So if that is not handled properly or understood at all, because sometimes we've gotten cases that were handled by other lawyers who didn't even understand that there was a construction accident, and they did not protect the client's rights as it should have been because they didn't know there was even a claim. So
Right.
it's critically important to manage. And I say, when I frame and manage, that you understand what record is going to be developed, what is going to be said, and who's saying it, because those are all facts that are going to be used for and against you.
One of the things, Joe, that you've emphasized over the years is that it's the clients that are the heroes, the real heroes. And if you reflect back, I know there's been some folks that they've been so kind to share their story with us in some of our commercials, et cetera. But if you reflect back over the 40 years or Rob's 25 years of doing this very, very specific, dedicated work for construction, what is one of the more interesting stories? I guess we'll wrap on this. Again, we're with Joe Stanley at Stanley Law Offices, stanleylawoffices.com. You can email as well, info@stanleylawoffices.com, or certainly Joe directly, which is joe@stanleylawoffices.com. We invite you to watch some of our construction videos and the things that we talk about as it relates to personal injury on YouTube, on the Stanley Law YouTube channel, and certainly here on Facebook, and as well as on Instagram, Twitter, LinkedIn. We're on all of those platforms, Joe. We're meeting people where they're at, right? But as we wrap today, Joe, what's one of the more interesting stories that you have over your career that you go, wow, that was a lot of work, but man, what great people, and was it ever worth it?
Well, I will start out with the bad, because sometimes you remember the bad, the ones that weren't fair, shouldn't have happened. And I think I mentioned a little bit about the erection case. This was a
Yes.
case that was a mining accident, and the pulley and that moved the material along was
Was
being
this in
erected.
Pennsylvania, Joe? Was this
No,
in Pennsylvania?
this is in New York. This is
Oh,
this
okay.
is a while
Okay.
ago.
Okay.
Um, it was a gravel mine. And anyways, they were erecting an addition to it, and it collapsed, and very nice person. And I got to know him very well. We did depositions all over the world on that. And we won at the lower court level, and the appellate court reversed the case on a fact claiming that made something up that was never even argued. The decision came out reversing, saying it wasn't an erection because the device that was being added was a option, not mandatory, which was a complete falsehood, by the way. It was not true. There was no information at all in the record. And therefore, since it was optional, it wasn't required an erected device. This is the kind of nonsense that you can get. And the case was dismissed. And I had to explain that to the client, and he took it way better than I did, and way better than I would have if I was him. Because the court, they didn't, they just move on to the next one. But for him, he had a very, very significant injury, and that was the end. In the end, that was nonsense. I mean, it was complete nonsense. I could say that now. If I had a chance to say it to the judges, I would have said it to them then. But when something's not even argued, and then just make something out that isn't under the facts. Now, this does happen, by the way, but it happened on more than one occasion in these kind of cases. But that one sticks in my mind. Another one that's
okay, another one. Yes, we have someone who just actually joined us in the chat room, Joe, and I'm just putting the information out. First of all, welcome, Marianne, and thank you for joining us. And I'm also putting out to any other guests on here. If you have any questions at all for Joe, just go ahead and type your question in the chat box. Or again, as we wrap up here today, you can ask your question on Facebook as well. Go ahead, Joe, with your
my final story.
more
I will
positive
remember this client. He was doing demolition work, and he was working. Well, the facts got very sad at the end, but he wasn't being paid much. He was demolishing this old building somewhere up north, I believe, and as he's demolishing it, a rebar came crashing through the whatever vehicle he was using to do the demolition, went crashing through the window and into his brain. The rebar impaled his brain. And he had a rebar in his skull. And
oh my goodness.
he was taken to the emergency. I mean, he had a very, very significant injury. Very. And it was so sad, as during the course of the litigation, the workers' compensation carrier, he wasn't getting much benefits because he wasn't earning much. He was living in his car. It was so sad because of the injury. He had cognitive issues, and we spent time. I don't know how many different. We finally got him set up. So you can't live in your car. No. But we got him set up, and we litigated that case, and we litigated it, and we argued the appeal. Now we argued the appeal, and they weren't really offering much until after the appeal, and they made a tremendously significant offer after the appeal because I thought they were going to lose, because at the time, this was a novel argument, and I didn't think it was enough.
What does that mean, Joe? At the time, it was a novel argument. What do you mean by that?
Well, the courts hadn't really addressed these particular facts. That doesn't mean anything anyways. It means that they had a clean slate versus a slate of 100 other cases that were inconsistent. But
Gotcha.
I didn't think it was enough for the injury, but I didn't think he could take the risk of not taking it. And he was going to take our recommendation because there was no independent basis for him to have other,
Right. If it's not this, you're risking too much because the likelihood of you getting something more or something else is not great.
Well, if we win, he's going to get more. But if the appellate court affirms the lower court decisions, we aren't. So
right.
We're going to get anything. So that was an all or nothing. But we settled it, and he ended up doing well afterwards, as well as could be given the injury. And but for the grace of God, could go any of us, because that was a freak accident. They didn't have the right safety devices there, and dangerous work. It always reminds me how dangerous it is, and the strangest things can happen on a construction site, and they do.
And they do.
That's why we have these protections, and that's why I really argue that the courts, when they try to limit these protections, is not the right thing. Those statutes were passed because they wanted the workers to be protected as much as possible. So that's my preaching for the day, and hopefully somebody understood something about what I said. But I think
the takeaway is what you've stressed for so long is that you really need someone on your side that's there, that's going to be there for you, that has walked this path many, many times. It's no different than, you know, you're going to go and have a complicated brain surgery. You're going to have some kind of complicated medical surgery. You do not want a general practitioner operating. You just don't. You want the best of the best. And sometimes the best of the best means that they've been doing it for so long and they've seen so many variables and scenarios. And you have the benefit. I mean, how often do you, I've been in the office before, Joe, where you got the benefit of conferring with Rob. So you're not walking this alone. I mean, you've got someone else there by your side that I would think, I mean, is highly intuitive in this. And I would think that the two of you confer and collaborate a great deal. Do you not?
Well, we talk about these cases every day. So yeah, I've actually, we talked about two of them today, as a matter of fact. So it's, yeah, it's what, you know, we both enjoy doing this kind of work because it is rewarding, and it can be challenging, and you know, that's what keeps your interest in anything you do.
Yeah. And I think, well, I think more and more we've been saying, I mean, it's proving once again that when your partners, when your researchers, when your investigators, when your clients, when you all work together, you win. You win. So, well, very good. Thank you to everyone who has joined in, who's asked a question, who's participated today. Of course, this will be up on Facebook and archived for your reference and for sharing it with family and friends, people that you think it's relevant for them to take a listen to, and even someone who is a contractor, right? Not necessarily just for workers, but people who own companies, businesses, properties where there is potential liability, ensuring that your grounds and your mechanics and your building and your stairs and everything is safe for the well-being of you, your family, your employees, and the general public. We invite you to go to stanleylawoffices.com. The office phone is 1-800-608-3333 with offices in Syracuse, Watertown, Rochester, Binghamton, and in Pennsylvania in Montrose. Thank you, Joe, for all your input and insight and all the work that you and the team at Stanley Law do. And we all hope you had a wonderful Independence Day weekend and stay safe out there. Enjoy the rest of your summer. We'll be back again with yet another webinar, probably sometime during the month of August. We try to do this at least once a month, and as always, advocate and educate. Be your own best advocate first and foremost, but when you need help, it's there for you at Stanley Law. Thank you, Joe. Be well. See you again soon.
Thanks, Angela.